Thank you, Madam Clerk, and good afternoon and welcome to everyone. This is the December session of the Tennessee Court of Criminal Appeals. Our Zoom arguments being live streamed on the internet, on YouTube, at the TN Courts channel. We wish to thank the lawyers for appearing today and helping us use this new technology. Thank the Clerk Jim Hivner and his staff and the staff at the AOC for making all this possible. We would prefer to be in person hearing, but in our attempt to help with a solution to the spread of COVID-19, we're trying new technology to help minimize any spread and to help keep our cases moving in a timely manner. The panel that will be hearing your cases today, on the right of your screen from Memphis, Tennessee, is Judge Ross Dyer. On the left of your screen, also from Memphis, Tennessee, is Judge Camille McMullen. I'm John Everett Williams from Huntington, Tennessee, and we are delighted to be here with you this afternoon. The cases and the way they proceed on oral arguments, Zoom or in person, are the same. Each side is given 20 minutes. The appellant may have reserved some time for rebuttal, and they should do so upon introducing themselves to the court. I will try to help you keep your time and let you know when you're starting to get in your rebuttal time. And I generally interrupt you at about 15 minutes into your argument if you get that far or use that much time to tell you that you're getting close. With that, Madam Clerk, would you call the first case? Or the last case of the day? I'm sorry.
State of Tennessee versus Michael E. White.
The appellant may proceed, and your time starts now.
Good afternoon, Your Honors, and may it please the court. My name is Kendall Stivers. I'm an assistant public defender with the appellate division of the Public Defenders Conference. I'll be representing Mr. White today. I'd like to reserve 3 minutes for rebuttal time for court, please.
Yes, ma'am.
I'm going to go through, begin with a very brief factual summary of the case before the court today, before I go into my argument for anyone listening or watching today. Mr. White was placed on probation in December of last year. It was a 9-year sentence suspended to probation. It was a nonviolent drug offense. As part of his probation, Mr. White was to report to something called the Day Reporting Center. It's not clear from the record exactly what this is, but it was a service that they offered in Madison County for probation. Mr. White did not make a lot of his appointments. They sought a warrant and obtained a warrant. And when Mr. White had a probation revocation hearing, the trial court found that he had violated his probation and ordered him to serve his sentence in full. It was his first violation, and it is what they call a technical violation, which is defined by the TDOC as something that is not a new criminal offense. And he did not abscond, meaning that they weren't able to find Mr. White. So the reason we're here before the court today is not because Mr. White did not violate his probation. Mr. White, during his probation violation hearing, testified, and he admitted that he had violated his probation by not showing up. He admitted that he did not show up because he'd been using drugs again and was afraid to go in because they would drug test him.
I know they didn't mark it as a violation, but he admitted to 2 violations, didn't he? He admitted to the violation of not showing up, and he also admitted to the violation of using illegal drugs.
Correct.
So, I recognize the warrant just says he didn't show up, but can the trial court not also take into consideration his admission during the hearing that I was using illegal drugs?
Oh, absolutely. Absolutely. We're not contesting that there was a violation of probation here.
No, I'm just saying when you look at it, it's not just this one technical violation. There's other violations the proof showed once we got to a hearing.
Correct.
Okay.
Correct. he admitted that he would have tested positive for illegal substances. There is, and we argue, and the state agrees in its brief, that there's a two-prong analysis that a trial court must go through when determining what to do with somebody's probation once they have violated it. Well, the first part being whether or not there was a violation of probation. And the second, whether or not the trial court, in going through the options that are available to it, once it finds that there is a violation of probation, whether the trial court abused its discretion in what it decided to do with that probationer's sentence. Once there is a violation of probation, trial court can choose from, by statute, a partial revocation or incarceration for a brief period of time and return the person to probation. They can reinstate them to probation and modify some of the conditions to ensure that the person is more compliant with their probation this time. They can execute the original sentence, which is what the trial court did here, or they can extend the probation for up to 2 years. The problem that in this case I've run into, and in other cases where we've had violations of probation, is there's really no guidance for what constitutes an abuse of discretion from a trial court in determining what to do with a person's probation. We're well aware that they have in their power the ability to order the execution of that sentence, but as I've included in this brief, from the criminal justice initiative, the task force that Governor Lee formed to determine why Tennessee has an incarceration rate that's 10% higher than the national average and why we still have such a high rate of recidivism, that perhaps the solution may be found in the answers that they came up with and recommendations that they came up with in their report. For an abuse of discretion at the second part of a probation revocation hearing, the court has to find, or this court has to find, that the trial court made a conscientious and intelligent decision in choosing from among its options as to what to do with the probationer's violation, and that they did not act arbitrarily. The trial court did not act arbitrarily in doing so. And that's exactly what we're arguing the trial court did today. Mr. White does have problems. He did admit to taking illegal substances while he was on probation. He didn't show up 35 times. He didn't show up even when his probation officer came to his house and tried to get him into the program that he needed to complete as a condition of his probation. That being said,
Ms. Stivers?
Yes.
I guess I read your brief, I read your reply brief, all very, very good product. But with your client having 35 unexcused absences, that in addition to, I guess, his probation officer or the policy in place of supervision allowed there to be another layer of discretion. They repeatedly excused, or they didn't file a violation report pertaining to your client until his 36th or 37th absence, unexcused absence. And my view of this case is that, what there was not much left for the trial court to do. The probation office is taking into account a lot of your policy arguments that you make in your brief. And, if you talk to some trial judges, they may be upset with how much discretion or what the probation officer is permitted to do at this point. So, I get your brief, I get your point, but the probation officer and the probation office had a tremendous amount of discretion, and trial court could have been upset at this point for them having waited so long to bring him before them to address what clearly was a drug problem in this case. But again, I'm not sure what you're asking this court to do, because your policy consideration, your policy arguments were clearly addressed here, because you had what I believe to be a probation officer who was very concerned about your client.
That's true. We're asking for guidance. In a nutshell, we have no idea. We have this two-prong analysis, and where a trial court can abuse its discretion in determining whether there's a violation and determining what to do with the violation, but we have no idea what constitutes an abuse of that discretion. In my reading through case law, there's never been a finding that the trial court abused discretion. And one of the things that the case...
Excuse me, but I think that's your answer. You, in seeking this extraordinary relief of telling us that a trial judge is abusing his discretion by following the law and giving a sentence that is clearly contemplated by statute, you cannot come up with one that has been successful in this court. That's why I consider most of these Rule 20 cases, as heartless as that sometimes may sound. Here we're looking at a young man that is, you call it a technical violation, 9 years of probation and missing 35 days, I might find technical. Missing 35 days in 3 months, I don't find that technical. That's just an abrogation of his responsibility to comply with the program, complete and total. He's getting no use out of this whatsoever. And he's just thumbing his nose up at anything that the court's trying to do to help him. So how could that possibly ever be an abuse of discretion when the trial judge just says, sir, I've given you every opportunity to take advantage of these programs and you refuse to do so, you may go to jail?
Well, if the court's opinion is that a trial court can never abuse its discretion, then there doesn't need to be a second prong to begin with.
No, ma'am, I've told you haven't ever given it to nobody. No one has ever given us one. We don't make them up. We're not to make them up. We look at it if that's what you want us to look at. But how can you have an agreed upon statutory scheme where this punishment is allowable, and under these facts, this gentleman abuses discretion? This judge abuses discretion.
Well, the implication then is that if someone violates their probation, then the only punishment is incarceration for something this egregious, which is exactly what the task force said is the inappropriate thing to do. They found that the person is
force doesn't have the force of law. I'm following the guidance. I'm trying to follow and believe I'm following the guidance that the Supreme Court of the state of Tennessee has given us, and it is broad. It is large, and I'm sure you. I hope you have. I think I'm keeping up with them. You've had about 11 cases with us. I hope the Supreme Court takes it and straightens this out for you. But until they do it, I don't see how I can.
I can't cite any law if there's never been an abuse of discretion. The only thing that I can repeatedly ask this court in looking and giving this court opportunities to examine fact patterns and find what does or does not constitute an abuse of discretion is this task force. They recommended a proportional response, which is not one violation, you're in jail for 9 years, which is what we had in this case, especially when it shows that the most likely time for them to violate is in the initial few months of them.
To Judge McMullen's point, you don't have one violation. I mean, you have a probation officer who allowed numerous violations. You have a probation officer who went commendably the extra mile and went to the defendant's house twice, I think, and tried and set up an appointment to try to get him to come. You have a probation officer who knew what was going on. He's using drugs, and if I could just get him in and get him help, it'll work. So to Judge McMullen's point, the probation officer fulfilled the recommendations by the task force, the policy recommendations. Your client failed to take advantage of that. And then now to Judge Williams' point, what's a trial judge to do? It may be one violation warrant, but it's not one violation. It's 35 violations of his probation that this probation officer continued to overlook. And I understand why, trying to get this guy help, but it didn't work. What else is a trial judge supposed to do?
The trial court is supposed to use the tools that the state has given it in terms of the day reporting and in terms of the other things that are trying to get these people off of drugs.
Ms. Stivers, can I ask you, you want to finish your point?
No, go ahead.
Did the lawyer below, did defense counsel below ask for split confinement, and would that have even worked in this case?
I'm not sure if that was part of the plea negotiations. I do know that he was, I think, incarcerated up until the point at which he pled. I don't know. I wasn't at the trial court level. I don't know if that was an option, but that could have been an option. And in fact, if trial courts are repeatedly allowed to operate under the assumption that when somebody violates their probation, when they're not committing new offenses, and when they're not injuring the public, that the only option is incarceration. Tennessee is going to keep having 10% incarceration above the national average. They're going to keep having people
Ma'am, respectfully, that's over our pay grade. That is with the legislature, the executive branch, and perhaps with the Supreme Court. If we gave him split confinement, you would come here with a very good and compelling argument that it was an abuse of discretion to give that. If we put him back on a supervised probation in a very more intense version, you could come back and say that's an abuse of discretion there. You could always allege abuse of discretion, but you haven't proven it. You have to prove an abuse of discretion when the violations are this bad. It's not that there are not other programs available. There may be, and the judge just didn't think it was prudent for this particular individual, that he had violated it so much. So what am I supposed to do? If the legislature wants to change it, I'll follow it. I promise. But they haven't. They've given this power to the trial judges. I can't usurp that.
Well, I'm not really sure what we would have argued had he been given a split confinement. What I can argue is what is before the court today, which is that we seem to be going in circles, that we can't find an abuse of discretion because we don't know what abuse of discretion is, or if a trial court has one of four options to choose from and they choose from one of those four options, then it's not abused, it's discretion. What I do know is my client has a right to appeal,
Sure.
And that this two-prong analysis exists. So,
and do you recognize you have the burden to show us what the abuse of discretion is?
Absolutely. The abuse of discretion is that this person is a drug addict, and there is no causal connection between putting someone in jail for 9 years to help with the recidivism rate or the overcrowding in prisons.
Counsel, the only thing that I will say in response to that, counsel, and you probably know full well that this is coming. The problem with that analysis is the whole point is to rehabilitate your client. And if your client refuses to cooperate, there are no more options for the trial court. And in a trial judge's mind, they are thinking this individual is going to either continue to violate the law and hurt themselves or someone else. And who is that going to come back and affect? The trial judge, because the trial judge has to recognize those two things and protect the public. And you know that.
Correct. But what Mr. White's behavior showed when he was out on a suspended sentence was that he was he was nonviolent and he wasn't reoffending. He wasn't committing new criminal offenses. He was committing offenses. He was testing positive or not testing positive. He admitted to taking drugs while he was on probation, and he's not showing up. If a trial court wants to address the problem with the suspended sentence and not keep having that person come back in, they can fully revoke a person's sentence for a partial amount or a partial revocation and get their attention. Because those initial 3 months when someone comes out of jail, being a drug addict and not having drugs, it's like letting a kid into Walmart during Christmas time or something like that.
Respectfully, counselor, you're getting into your rebuttal time, and no, the judge can do exactly what he's been doing, and that's sentence them to serve their full sentence. They don't have to give them probation or any other alternative form of sentencing. Once you had one bite of the apple without proof from the defendant that they abused their discretion, their one option is full incarceration. And that's what they did, plain and simple. Your argument sounds better to me in the legislature or with the Supreme. We've had this discussion 2 or 3 times, but you'll get there and you'll get your answer someday. I fully hope, and I appreciate the advocacy you're giving.
With that, I'll rest and wait for my rebuttal.
Okay, thank you.
Yes.
General?
May it please the court, Brent Cherry for the state. I think the court, just from the argument that's occurred, I think the court has a pretty good handle on what the situation is here. We have an individual who pled guilty to sale and delivery of meth and agreed to a 9-year sentence. Part of the agreement involved going on probation and meeting specific requirements in order to stay on probation and not go to prison. And clearly, the defendant simply did not comply with the conditions of his probation. And I think the court has already indicated and recognizes what is a trial court supposed to do in a situation like this. You have someone who's agreed to these terms, and yet they're not abiding by the terms, and not just in a little way. Judge Morgan, as we look at the record here, Judge Morgan was disturbed with this case, indicates that, hey, when we first started and we went into this and we established this probation, Judge Morgan was happy about this. He was giving somebody an opportunity to put their life on track and to go forward and overcome these issues and problems. And he was very frustrated when he saw this individual come back, because it wasn't just a minor violation of probation. We're talking about 35 unexcused absences from the Day Reporting Center program over a 3-month period. He only went to the day center 5 times in that 3-month period. He just wasn't doing anything to help himself. And it's obvious that the probation officer and the director of the program were bending over backwards to try to help this defendant get back on track and to get his life straightened out. They went so far as to go to his house to try to meet with him and get him into the long-term drug treatment program, but he just simply refused to work with them. So what else is a trial court supposed to do? Judge Morgan knew what his options were. He knew what he could do. He could just put the defendant back on probation. He could revoke for a little while and put him back on, or he could revoke probation entirely. And he determined that this was appropriate to simply revoke probation in full, because this defendant was simply not working with the program, was not willing to do the things that he would have to do to get on track. And you can see the heartache by Judge Morgan as he looks at this case. There's not a lack of compassion or a lack of understanding or a lack of wanting to help this defendant. There's not a lack of discretion here. He exercised his discretion, looked at all the circumstances, and determined that this was really the only viable option to fully revoke probation.
General, can you help me out? And I know you've thought about these cases. You've been with us a long time. Is there a factual pattern that you can think of that violates the abuse of discretion statute or standard in revoking these and requiring full service of the sentence?
Your Honor, I really can't. I think the only situation that comes to mind, if a judge just determines, you know what, every case, I'm never going to consider anything else, but if they violate, it's full revocation. But we don't see that here. I don't know that I've ever seen that really in a case. We see too many cases where judges are giving way more chances to these defendants than a lot of us would think they deserve. So
you know, playing devil's advocate and trying to help, I can't write an advisory opinion and say, okay, I think in these 4 possible circumstances, but we do look at degrees. And here we've got 35 days and 3 months. You know, if you missed 2 hours one day, would that do it? I mean, wouldn't it all depend upon the circumstances of that day and how important those 2 hours were, and whether, you know, I just can't. I just can't seem to help come up in my mind something that I could write down that would give the defendants a better standard than what we have right now.
I think you're right, Your Honor. We've got the standard set up, and we've got a program set up. And again, we go back to this situation. We've got this probation officer that's bending over backwards. She's not wanting to file a warrant on this defendant, giving him 35 chances, in addition to his admission that he's doing drugs, in addition to the fact that he won't show up to try to get into a treatment program. It's just this situation where everybody's really bent over backwards to help this defendant. And when he's thumbed his nose at the system and at the program and at the people that are trying to help him so many times, there's really no viable option except to fully revoke his probation and send him back to prison.
Well, why couldn't the trial court have said, okay, I'm going to violate you, and I'm going to impose, 90 days incarceration and then revisit this issue?
He could. That's absolutely within his authority to do that. But it's not he's not violating his discretion by saying, look, you haven't shown any effort here. I can't see any reason not to fully revoke your probation. I mean, we're talking about a 9-year sentence. He wasn't just
we're talking about service, complete service of a 9-year sentence on a not a first violation, but again, these are unexcused absences, and you've got a situation where a defendant is clearly, he has a substance abuse problem. And just to the policy arguments made in defense counsel's brief, the only concern I have is that there wasn't a gradual response. I know the probation officer gave the gradual response, but I'm concerned, again, you've got what the probation officer is supposed to do. And in considering what's before the trial court, this was really the first time he got to look at the defendant again in the 3-month period. The first time before the court, would it not have been wise to maybe do something more like a gradual, response to what this gentleman was going through? That's really what they're arguing for. They're arguing for just more of a gradual increase in punishment rather than complete confinement.
Right. Well, Your Honor, I think you already kind of alluded to the answer to that question already. When you talk about this situation, I don't think you necessarily need to say, okay, everybody in the parole board office does their thing, and then we begin all over again with the judge. I mean, this is something we can look at all together. This guy already had not just one bite at the apple, he had 35 bites at the apple before it gets to the court. By that time, it's like, good grief. This ship is already taking on so much water, it's going to be hard to bail out enough to get this up on the sea again. So in a situation like this, I think we've already been through the gradual approach by the time we get to the court. And the court is the one that just has to let the hammer drop.
All right.
With that, it's a tough situation whenever you send somebody to prison, and this gets personal for some of us because we know people that have had substance abuse problems and have had to deal with the justice system and had to deal with people in the probation and parole system. But at some point, there has to be an end and a finality to this process, and the judge has to make those hard calls. And this is one of those situations where this defendant has simply failed to comply, and it's time for him to go to prison. And so he did not abuse his discretion, and the state would encourage the court to affirm the judgment of the lower court here.
Yes, ma'am. You have your full 3 minutes.
Thank you, Judge. If someone, Your Honor posed to Mr. Cherry a question, if someone had violated by being late 2 hours on one day, whether that would constitute a violation and whether or not that would authorize the trial court to order full execution of the sentence. And under the standard that we're working with, the answer would be yes. It absolutely would. And if the abuse of discretion is for the trial court to make a conscientious and intelligent judgment and to not act arbitrarily, then putting someone who is who's been abusing drugs in prison rather than putting him in jail for a couple 30, 60, 90 days to give them a taste of what they might be looking at if they don't get their act straight is not something that is so far out of line that we choose then to spend state funds on trying to rehabilitate somebody and using those resources like a probation officer or community corrections rather than paying to house them. I keep going back to the task force because it's the only thing I really have. But what they found was that there was an over-reliance on incarceration for nonviolent individuals and technical violators. I know it's not this court's obligation to solve the problems that the task force tried to remedy, but there has to be some manner in which a trial court can abuse its discretion, and we would argue in this case that by sending somebody to prison for 9 years on his first violation when he didn't harm anybody, which was purpose of the releasing.
Would 8 years make a difference?
Would 8 years make a difference in what, Your Honor?
Yeah, I mean, you can't do it for 9. Would he same thing if it was 8 years?
Could you rephrase that? I don't understand the question.
In other words, you said that if I wouldn't consider an abuse of discretion for 9, well, what about just 8? If you just sentenced him to 8 years instead of 9, would that be okay? Or would that still be an abuse of discretion?
The abuse of discretion comes not from the manner of the length of the sentence, but the fact that there was an order of an execution of a full sentence on a first violation.
Oh, okay. So that's what you want me to say. That is, I understand that. I understand that you say if there is a first violation, there cannot be a full imposition of the sentence. I think that takes legislative action. I am sympathetic towards folks that have these type of problems, very. But I cannot, at this level, supplant my wishes and my will and my compassion for the trial judge that has to deal with it every day. And I don't think the Supreme Court has given me any authority to do that, given the situations they have. I will ask you, have you had a chance to appeal any of these decisions to the Supreme Court? And are they taking any of them?
No, Your Honor. And what we're getting, and I think a little bit of why we've had so many of these cases is that there isn't really a uniformity in how the trial courts are deciding. We get sometimes there's a one-prong analysis. there's a hybrid analysis. There's 2 abuses of discretion, both at the trial court before the trial court to find a violation, and then for the trial court to what they do with that probation violation. And we're coming to the court with nothing basically in terms of guidance and case law as to what constitutes an abuse of discretion, because it's never been found on that second prong.
That is a perfect example for the Supreme Court to tell you the answer. When our 2 courts, when we have panels of our court that are doing different things, that is when the Supreme Court, I think, loves to come in and says, this one's right, this one's wrong, this is what you need to do. And I would be more than happy for them to give us some guidance. But I don't think it's my place here. I've been following this. It changed. We used to change sentences all the time. We haven't changed sentences in a long time. Matter of fact, at one particular point in time in my career, a short period, jury sentences were unappealable. You could not challenge a 15-year sentence at all. Period. They were unassailable. But we've come a long, long way since then, and we're still moving towards coming a long, long way. But it's as sympathetic as I might be. I just don't think the law permits me to do. And I like the way you phrased your last argument, because that's what it boils down to. I can write down a rule that says first offenses don't count towards the violation of, you got to fall in some kind of range. But that I know is not my authority. I just don't have it. That's the legislative authority.
That's great. And we're not asking to say a first violation doesn't count. We're just asking for it to be proportional to the offense. And with that, if the court has no further questions, I'll rest. I
think both of y'all have done a very good job of setting forth your issues. I think it is fully understood, and that is the best compliment I can ever pay an attorney when they're standing before us in a case of this nature. So I hope you appreciate that. Thank you for helping us make history with the Zoom this particular time. I'd like to thank my colleagues. They've been over backwards for me and my desire to do this, and my feel that there's a great need for us to try to use this tool to help it and our society in this pretty tumultuous time we're going through right now. Don't think that's the right word I need, but it's the one that I use, so I'll have to stick with it. Thank you all for participating, and we will stand adjourned unless there's any thing from the panel. Anything? Best wishes over the holidays, I assume, to all. And we will retire until the call of the docket next month and next year.
This honorable court stands adjourned.
Thank you.